Okay, as Dean Singer said, we're just going to go through business entities. I tend to be pretty concise, and I tend to talk fast. So tell me to slow down anytime it gets to be too much. I won't be offended. I know I do it. We're starting out with corporations, then going to not-for-profits. Oh, I don't know if I'm on.
Actually, yeah, you are. You know what we need to do? I'll run. I use a hand mic. So that mic goes to that camera, and you need a second one.
Oh, okay. Guess let's pause for a minute.
Do you mind projecting into the
Sure, I can try to project. Okay, so initially in the handouts here, you see that there's a table that compares the different types of business entities. That's just meant to be sort of a quick reference, and we're not going to go over the table. I'm not sure how to do that talking, so let's just skip by that and start with corporations. Okay, a corporation is a separate juridical entity. It's separate juridical entity. Juridical?
What's a juridical?
Juridical, J-U-R-I-D-I-C-A-L. Which means the corporation is separate from its officers, directors, and shareholders. Okay, we're working on projecting. Okay, in order to begin its corporate existence, the incorporators must file the Articles of Incorporation with the Secretary of State. So it's Articles of Incorporation. You got my mic? Well, this is going to be even weirder. Okay, so corporate existence begins upon filing. If a person acts with actual knowledge, so again, if a person acts with actual knowledge that the Articles of Incorporation have not been filed, he is jointly and severally liable for all liabilities incurred while so acting, unless the third party also had actual knowledge that the corporation had not been created. Okay. So I know joint and several liability has largely been abolished, but in our corporate statutes it still exists as a concept. So for these purposes, there's joint and several liability. The incorporators are one or more persons who deliver the Articles of Incorporation to the Secretary of State for filing. And there's certain provisions the articles must contain. The first mandatory component is the corporate name. So again, it's the corporate name, which must be distinguishable from other corporate names. Now, distinguishable is a pretty low standard. It could be the presence or absence of a comma is sufficient for distinguishable. The name must contain language indicating that the entity is a corporation, may not imply any illegal purpose, and may not imply a connection with a state or federal agency. That implying an illegal purpose, we're seeing a lot of that with what's happening with medical marijuana versus recreational versus whatever is going to happen in Florida. Thank you. And so there's a lot of companies now that are incorporating with something along the lines of sale of marijuana in their name. That's not a lawful purpose in the state of Florida at this time. Okay. Next is the address of the initial principal office. So again, it's address of the initial principal office. Third is the number of authorized shares. Fourth is preemptive rights, but see the footnote? I'm not sure. So although preemptive rights are the only opt-in provision mentioned in the articles, there are other opt-in provisions in the state under the statutes, cumulative voting and par value. We'll come back to those. The next mandatory provision is the address and name of the initial registered agent. And finally, the name and address of each incorporator. Now, the articles may contain, so now we're going into permissive. First, the names and addresses of the initial directors. Next, the purpose statement. Third, any provisions regarding management. Fourth, any other corporate powers. Then par value and any liability of shareholders for the debts of the corporation. Next, the concept of ultra vires. Under Florida law, a corporation can be formed for any lawful purpose. Further, except under very limited circumstances. Oh, sorry, I think I'm getting ahead. The validity of a corporate act may not be challenged as being beyond the corporation's power. A corporation may be, a corporate action may be challenged first by a shareholder to enjoin the action. So again, by a shareholder to enjoin. Second, by the corporation itself against a current or former officer. Third is by the Attorney General to dissolve or enjoin. Now, powers of the corporation. A validly formed corporation has all the powers of a natural person. Again, all the powers of a natural person, including the right to sue, lend money, make charitable contributions, or make political contributions, limited, of course, by campaign finance limits. Charitable contributions, may be made for, among other purposes, public welfare, scientific, or educational purposes. They tend to like to ask questions about making charitable contributions. Not sure why, but I think it's meant to trip you up a little bit. But as long as it's a valid charitable purpose, the corporation can do it. Next, shares and free transferability. Ownership interests of the corporation are divided into shares. The shares are the units in which the proprietary interests in the corporation are divided. The number of authorized shares is the total number of shares that the corporation is authorized to sell. And remember, the number of authorized shares has to be set forth in the Articles of Incorporation. The number of issued shares, again, that's the number of issued shares, is the number of shares which have been sold. Third, the number of outstanding shares is the number of shares which are actually currently owned by the public. And finally, treasury shares are authorized and issued but are not outstanding. So we'll do a brief example. Corporation X has 500 authorized shares. It sold 300 of these shares and reacquired 200 of those shares. It then sold 100 shares on June 30th. So how many shares are authorized? That's going to be 500. And that would again be set forth in the Articles of Incorporation. How many shares are issued? That's 400. It sold 300 and sold an additional 100. How many shares are outstanding? There are currently 200 shares outstanding.
How many were authorized? I'm sorry to hear.
Oh, the authorized are 500. Yeah. And again, that would be the number set forth in the articles, is the maximum number the corporation can sell. Next, a corporation may have... Sure. That's the number of shares that have been sold. So we sold 300 initially and then sold another 100. So think of issued shares as sort of used shares. So we're not going to worry about what's been bought back. We're only going to be worried about what's ever been sold.
So when they're reacquired, can be changed.
Right. So just like I said, think of issued as used of a sort. Next, a corporation may have classes of shares. Each class must be distinct. All shares in a class must have identical preferences, limitations, and relative rights. There must be at least one class of shares with unlimited voting rights. It's unlimited voting rights. And at least one class of shares with unlimited economic rights. Economic rights are the rights to receive the net assets upon liquidation. Now, if you only have one class of shares, that's just going to be a class of common that has both unlimited voting and unlimited economic rights. Shares may, but do not have to be, evidenced by a certificate. If a share is not evidenced by a certificate, the issue must be accomplished by an informational sheet. The informational sheet must set forth first the name of the issuing corp, second, the name of the person to whom issued, third, the number and classes of shares, and fourth, if the corporation has different classes of shares, the designations, relative rights, preferences, and limitations must be summarized.
Can we slow down just a little?
Sure, I'll try. The next concept we're going to look at is free transferability. Free transferability generally indicates an ability at any time to sell one's shares. A corporation can restrict the free transferability of shares, but the restriction must be conspicuous on the certificate or info sheet which accompanies the shares. Conspicuous for these purposes can mean a different font, a different size, bolded, italicized, underlined. Okay. An example of a restriction could be that the purchaser may not sell within the first 6 months of acquisition, or that the corporation or other shareholders have a right of first refusal to purchase the proffered shares. A purchaser for value will not be bound by a restriction of which he has no notice and which was not stated on the certificate or info sheet. Okay, now let's consider preemptive rights. So preemptive rights, the presence of preemptive rights must be contained in the articles. Remember, that's an opt-in provision, so if you're going to have them, they must be in your Articles of Incorporation. A preemptive right is a right to maintain a proportionate amount of unissued shares upon their issuance. That's proportionate amount. A preemptive right may be waived. A waiver, if in writing, is irrevocable, even if there is no consideration. That tends to be asked often. Now, even if otherwise available, a shareholder does not have a preemptive right to purchase first any shares issued as compensation. So again, that's shares issued as compensation. Or shares issued for consideration other than money. Okay, now let's talk about shareholders. Shareholders are the owners of the shares of the corporation. And shareholders can purchase their shares for any consideration, including first, money, second, promissory notes, third, services performed, so that's past services, fourth, future services, if evidenced by a written contract, and fifth, other securities of the corporation. Pay special attention to the future services, evidenced by a written contract, and the past services. Okay. Next, the board of directors. It's the board of directors determines the adequacy of the consideration received. So, for instance, you wouldn't have that problem with money or promissory notes, but the board would have to consider what the past services or future services were worth to the corporation. Shares may be acquired by subscription. And that shares may be acquired by subscription. A subscription for shares is irrevocable. So a subscription for shares is irrevocable for a period of 6 months, unless the subscription agreement calls for a longer or shorter period, or all subscribers agree to revocation. Note that it has to be unanimous. Okay. To be enforceable, a subscription agreement must be in writing and signed by the subscribers. Shareholders may receive distributions. A distribution. Distribution? Yeah.
What is the subscription?
It's really just an agreement to purchase shares in advance of their issuance. Okay, so think about kind of the common use of the word subscription, and it's pretty much the same thing, just it's the ability to acquire shares.
Before they've been issued?
Before they've been issued. Sure. Okay. So shareholders may receive distributions. A distribution is a direct or indirect transfer of money or other property, except the corporation's own shares, or the incurrence of indebtedness by the corporation to or for the benefit of the shareholders. In order to make a distribution, any distribution must be authorized by the board. Again, any distribution must be authorized by the board. And the record date for any distribution is the date the distribution is authorized. Okay. Also, the record date is the date on which the corporation determines the identity of the shareholders and their interests. Now, there are 2 tests for making a distribution. The first is the equity insolvency test. And that's the equity insolvency test, which demands that the corporation must be able to pay its debts as they become due in the regular course of business. The second test is the balance sheet test. Under the balance sheet test, it requires that the total assets must be at least equal to the sum of the total liabilities, plus the amount needed to satisfy any preferential rights. Next, a share dividend. That's a share dividend, is a distribution of shares on a pro rata basis and without consideration. A share dividend is not required to meet either the equity insolvency or balance sheet tests. So shareholder meetings. The annual meeting may be held in or out of the state. I've seen that tested. I'm not sure why. They try to get you to say that it has to be in Florida, but that's not the case. A special meeting must be or is limited to the purpose set forth in the notice of the special meeting. Now, notice with respect to either a special or an annual meeting must be preceded by at least 10 days' notice, but not more than 60 days' notice. Okay, and it's for both your annual and special.
Just because Delaware corporations are like popular, does that also apply to Delaware Corp meeting in Florida?
We're ignoring Delaware Corps because we're not, yeah. Yeah, you don't need other state law at this point. Yeah. I don't think they would ever ask something like that. So just limit to Florida. Yeah. As fun as it would be to go through the other states, let's stay focused. Okay, shareholder voting. Generally, it's 1 vote for 1 share. Shareholders may vote by proxy. So again, shareholders may vote by proxy. A proxy is valid for up to 11 months. And a proxy is generally revocable unless the proxy document states that it is irrevocable and the proxy appointment is coupled with an interest. Coupled with an interest. Okay? An interest for these purposes could be a pledge or a contract for sale. An irrevocable proxy becomes revocable when the interest it is coupled with is extinguished. So if it was used as like a pledge and the money is repaid, that interest would be extinguished and the proxy would become revocable. So notice that it's not immediately revoked, right? It just becomes revocable when the interest expires. Okay, a quorum is required for any action. A majority of votes entitled to be cast at a meeting, oh, that should be cast, not case. A majority of votes entitled to be cast at a meeting constitutes a quorum. A quorum cannot be broken by a shareholder leaving. That seems to come up a lot too. Somebody shows up to the meeting and then gets hostile at whatever's happening at the meeting and tries to leave so no action can take place. Once you're counted for quorum purposes, you're there, whether you leave or not.
So this is the majority of voters who you either submitted a proxy or is present?
This is the majority that are present at the meeting.
Majority of all shares, just present or proxy?
Right,
Okay.
yeah, it's present. So the required number for a quorum can be reduced from a majority to not less than 1/3. Okay, next, cumulative voting. And remember that cumulative voting is an opt-in provision, so if you're going to have it, it has to be in your articles. If cumulative voting is authorized, a shareholder may cast as many votes for directors as a shareholder has shares, multiplied by the number of directors to be elected. Cumulative voting generally encourages minority representation on the board.
Can you repeat that first one?
Sure, cumulative voting. Again, cumulative voting encourages minority representation on the board. The effects of cumulative voting can be defeated by specifying classes for directors or reducing the number of directors. Now, voting arrangements amongst shareholders. The first type of voting arrangement is a voting trust. And a voting trust, like all other trust arrangements, separate legal and beneficial ownership. So in this type of arrangement, shares are actually transferred to the trustee. And the trustee is under a duty to file a list of participating shareholders with the corporation. So in other words, a voting trust is not a secret arrangement. The corporation both has notice of it and has a list of the participating shareholders. The second type of voting arrangement is a shareholders agreement. Unlike the voting trust, shareholders agreements are private contracts which are specifically enforceable between shareholders. So again, they are specifically enforceable. Okay. Now let's consider shareholder derivative actions. In order to bring a shareholder, sorry.
Of course, I have another
Sure,
question.
no worries.
With the voting trust, the trustee, does he have to vote according to, what is the people?
He's going to vote according to the best interests, what he believes the best interest of the voting trust. So, and he's acting as a trustee, so there's a fiduciary component. But he's not beholden to, if shareholder says vote for A, he doesn't have to do that. He has to act in ways that he considers the best interest of the trust generally.
But with the shareholders agreement, whatever way they say they have to vote, they have to.
They have to. Yeah, it is specifically enforceable. Okay. All right, so back to derivative actions. In order to bring a shareholder derivative action, the person must have been a shareholder when the transaction complained of occurred or have become a shareholder through operation of law. For example, by inheritance. And you see this a lot in environmental cases where, like the Gulf oil spill, somebody buys shares in the oil company following the spill and then tries to sue because of the environmental damage. If you own shares at the time it happened, you have the ability to bring a shareholder derivative, but you can't buy them afterwards and expect to have a cause of action. Okay, the complaint in a derivative action must be verified. So the complaint must be verified and allege with particularity the demand made to get the board to act. This is known as the universal demand requirement. So we don't have the concept of demand futility in corporate derivative actions. Okay. If the court finds that the board or advisory or special litigation committee made a reasonable investigation of the shareholders' issue and concluded in good faith that maintaining the action would not be in the best interest of the corporation, the action will be dismissed. Once brought, a derivative action may not be discontinued or settled without court approval. So now let's talk briefly about fundamental corporate changes. In the event a corporation is undergoing a fundamental change, for instance, a merger or sale of all assets outside the regular course of business, or a share exchange, consider who will be affected. The affected party is the party who gets to vote on the change and who may have appraisal rights. So if you're part of Corporation A, and Corporation A is absorbing Corporation B, your rights as a Corporation A shareholder continue uninterrupted. So you wouldn't necessarily get to vote. If you're part of Corporation B, you're being absorbed by A, you have the ability to vote on the merger. Okay, so just think about whose rights, preferences, limitations change as a result of whatever's happening.
Can you say that again?
Sure, I can try. Think about who's going to be affected. So you mean my Corporation B, AB example? Okay. So if you're Corporation A and you're taking over Corporation B, you're going to absorb B. B is merging into A. The Corporation A shareholders, their interest is continuing unaffected, right? The Corporation B shareholders are going to become Corporation A shareholders, so their rights are fundamentally changing. So they get the ability to vote on whether or not to merge. So there's a lot of really complicated stuff that goes on about voting and fundamental changes, but fundamentally it boils down to who's affected, okay? So the affected party is a party who gets to vote on the change and who may have appraisal rights. So appraisal rights are not available. Again, that's appraisal rights are not available if the shares are listed on the New York Stock Exchange or the American Stock Exchange, or there are at least 2,000 shareholders and 10 million of value. Notice that's conjunctive. So you need at least 2,000 shareholders and 10 million of value. A corporation must give shareholders notice of the existence of appraisal rights in the notice of the meeting. A shareholder wishing to assert his appraisal rights must deliver notice of intent to demand payment. If the action is affirmatively voted, the corporation must send notice of the approval within 10 days and give shareholders a form on which to assert their appraisal rights and make an offer of value. The shareholder must execute and return the form to the corporation with their demand of payment or accept the corporation's offer. If the corporation disagrees with the shareholder's assertion of value, it must submit the matter to the court within 60 days. So another corporate characteristic is that of centralized management. The management of the corporation is centralized in its board of directors. Again, centralized in its board of directors. And the board of directors must be made up of individuals. A director must be at least 18 years old and is not required to be a Florida resident or a shareholder of the corporation. They like to test both of those things, so make a little star there or something. Okay, a director may be removed with or without cause. And a director may resign by delivering his written resignation to the board. The board sets its own compensation. So again, the board sets its own compensation, and this is not considered self-dealing. In questions on this, they'll try to lead you down the path where it sounds like the board's paying themselves exorbitantly and try to make you say that that's self-dealing. It's not self-dealing. It could be problematic in its own right, but it's not self-dealing. Okay, regular meetings of the board of directors may be held without notice of the purpose of the meeting. And special meeting must be preceded by at least 2 days' notice of the date. So at least 2 days' notice of the date, time, and place. And unlike shareholder special meetings, the notice need not describe the purpose of the meeting. For any action to be effective, a quorum must be present at the meeting to vote on the action. A quorum generally consists of a majority of the board, but the articles may consist of, or may authorize a quorum to consist of less than a majority, but no fewer than 1/3. So in other words, it's the same as our shareholder quorum, okay? Now, director duties. Directors must act in good faith. So directors must act in good faith with the care of an ordinarily prudent person in like position under similar circumstances and in a manner that he believes to be in the best interests of the corporation. So notice a couple things about this. The standard is that of an ordinarily prudent person, not an ordinarily prudent business person. And the question about the best interest of the corporation is subjective. It's what he believes to be the best interest of the corporation. Okay. In making his decisions, a director is entitled to rely on the opinion of experts, so accountants, attorneys, officers, employees. And in making decisions, a director may consider first the long-term prospects of the corporation. So again, that's long-term prospects. Second, the interests of the shareholders. Third, the social effects of the action taken. Fourth, the communities in which the corporation operates. And fifth, the economy of the state and nation. A director is not personally liable for monetary damages unless, first, the director failed by action or omission to perform his duties, and, so it's conjunctive again, such breach or omission constitutes first a criminal act. So again, a criminal act. Second, a transaction from which a director derived an improper personal benefit. So again, that's improper personal benefit. Then, in a derivative action where the breach or omission constituted conscious disregard for the best interest of the corporation or willful misconduct, or the breach or action constituted recklessness, so again, that's recklessness, or was committed in bad faith or with a malicious purpose. Now, if they're going to ask you a question under the director's breach, and they're going to try to get you to say it was reckless, they have to make it look extremely and excruciatingly reckless. That's not a standard you'll be able to miss in a multiple choice question. It'll look, smell, and taste reckless. Okay, now exceptions to centralized management. In a corporation of 100 or fewer shareholders, an agreement may be made to change the governance scheme of the corporation, even to get rid of the board. If such agreement is entered, it must be set forth in the articles. So again, it must be set forth in the articles, or made by unanimous agreement of the shareholders. So again, that's unanimous agreement. I would guess if you're going to see something like this, you're going to see a corporation with 10 or fewer shareholders. I can't imagine getting more than that to all agree to something. An action by a director, which would otherwise be a conflict of interest, will not be improper if, first, the relationship or interest is disclosed. So again, the relationship or interest is disclosed, and the contract is ratified without counting the vote of the interested party, although such interested party may be counted for quorum purposes. Second, the action is ratified by shareholders after disclosure. Or third, the contract or transaction is fair at the time it was authorized. Okay, So liability for improper distributions. A director who makes a distribution which violates either the equity insolvency or balance sheet test is personally liable to the corporation to the extent that the distribution was improper. So notice here that they're not liable for the entire distribution, only to the extent that it was improper. So our next corporate characteristic is limited liability. The liability of a shareholder for corporate action is extremely limited. A shareholder is obligated to pay full consideration for shares. So again, it's full consideration for his shares. And the veil of the corporation may be pierced, thus making the shareholder individually liable for the debts or liabilities of the corporation if the shareholder has participated in fraud, or illegal conduct which has led to the debt or liability. And, yeah,
Also, Neil,
sure.
just focus on that theory, or like, there's like 3 different theories for Pierce and Bill. I mean, what do you recommend?
Florida courts require at least a showing of fraud or illegal conduct. So I don't think they often test business entities as essays, unless I'm wrong. Has anybody heard differently? In an essay, I think you could go into alter ego and deep rock doctrine and all those types of things. But for multiple choice questions, you're really looking for fraud or illegal conduct, because that's what the Florida courts require. So, I mean, there are cases that discuss all these other things, but if the courts find liability and pierce the veil, they're always going to find fraud or illegal conduct first. Okay? So that's corporations kind of in a nutshell. Now we're going to look at not-for-profits. Okay. We're really looking at not-for-profits to the extent they differ significantly from corporations. So not-for-profits, the articles have required content. First is the name. Second is the street address of the principal office. Third is the purpose statement. And that should have been another bullet after purpose statement, with the following one being a statement provided for the method of electing directors. So statement provided for the method of electing directors should have been our 4th bullet there. And fifth, any provision limiting the corporate powers otherwise provided by statute. 6th, the street address of initial officers and the name of the registered agent. 6th is the name and address of each incorporator. Now, permissive content in the articles. First is the names and addresses of initial directors. Second, provisions regarding regulation of internal affairs. Third is the manner of termination of membership. So again, it's termination of membership. Now, bizarrely, in the not-for-profits, they're not called shareholders, they're called members. So it doesn't make any sense, and there's no legislative history, but that's what they are. Next, rights upon termination. Following is transferability or non-transferability of interests. And then distributions upon liquidation or dissolution. A not-for-profit can be organized for any lawful purpose. So again, any lawful purpose, not for pecuniary profit. Okay, distributions. A corporation may not make distributions to its members, directors, or officers, but may pay compensation. And if you've got a question about compensation of not-for-profit directors, you're going to be looking at other corporations similarly situated in the market. So if other directors of those types of companies make $400,000, $500,000 a year, it's probably reasonable for your subject directors to do the same. So it's considered in light of all other similarly situated corporations. So distribution may, however, be made upon dissolution. A not-for-profit may purchase back its memberships if after the purchase the balance sheet and equity insolvency tests are met. So the balance sheet and equity insolvency are the exact same tests that we use for distributions under for-profit corporations. So members, again, this chapter refers to holders of an interest as members rather than as shareholders. Members have no voting rights, except as set forth in the articles. Liability is limited to dues, assessments, or fees. Interests are generally not transferable. So again, interests are generally not transferable. And resignation of a member does not relieve the member from obligations that arose prior to resignation. So a member may be suspended or terminated pursuant to a procedure that is fair and reasonable and carried out in good faith. Now, directors of not-for-profits, the board must consist of at least 3 individuals. Remember, under for-profits, there was no mandatory minimum. Okay, so in not-for-profits, there must be at least 3. And that's pretty much it for not-for-profits, at least for me. Partnerships. A partnership is an association of 2 or more persons. So again, a partnership is an association of 2 or more persons to carry on as co-owners a business for profit. A partnership is a separate juridical entity that can sue and be sued and can hold property, but is a pass-through entity for tax purposes. For purposes of the bar exam, I wouldn't get really caught up in levels of taxation. I would just know kind of the general rules. Regular C Corp is double, pretty much everything else is single, unless you elect otherwise. Okay? The partnership statutes are default rules. The partnership agreement is a governing agreement. However, a partnership agreement cannot, first, change any filing requirements. Second, eliminate access to books and records. Or third, entirely eliminate the duty of loyalty. Now, formation of a partnership is formed when the definition is met, regardless of the subjective intent of the parties. So again, that's 2 or more persons to carry on a business for profit. So as soon as you meet that, you're a partnership. The following factors are not by themselves sufficient to find a partnership. First, holding property as joint tenants. So that's holding property as joint tenants. Is tenants in common, tenants by the entirety, joint property, community property, or as part owners. Second, the sharing of gross returns. So again, that's the sharing of gross returns. But where profits are shared, one is presumed to be a partner. So make sure mentally you're drawing a line between gross returns and profits. So where profits are shared, one is presumed to be a partner unless the profits are received as payment on a debt, for independent contractor services, or as rent. Sure. Which part? Sorry. Where profits are shared, one is presumed to be a partner unless the profits are received as payment on a debt, for independent contractor services, or as rent. Oh, sorry.
Yeah. What's the difference? Like, I always thought that.
Returns and
sharing of
profits?
So what's gross return?
Gross returns is basically everything you're bringing back in without considering deductions or
Like
costs of doing
overhead and stuff like
business
that?
or overhead, those types of things.
Pre-tax.
Pre-taxes. Yeah.
Thank you.
I don't like to use pre-taxes much. That shakes people up when you talk about taxes. But yeah, if you consider the pre-tax. Partnership capital is made up of contributions by partners. So again, partnership capital is made up of contributions by partners. Property can be acquired by the partnership. Property is partnership property if first it's acquired in the name of the partnership. Second, it's acquired by one acting in his capacity as partner. Next, property is presumed to be partnership property if it is purchased with partnership assets. Okay, so if it's purchased with partnership assets. Property is not partnership property if it is acquired only in a partner's name, even if the property is then used by the partnership. The partnership owns partnership property. The partners do not own it as co-owners. Now, agency under the partnership laws. Each partner is an agent of the partnership. So an act of the partner in the ordinary course of business binds the partnership. So again, that's an act in the ordinary course of business binds the partnership. An act of a partner outside the ordinary course of business binds the partnership if the partner acts with authority given by all other partners or such action is authorized in the written partnership agreement. So partner's liability. A partner is personally liable for all partnership obligations. He's personally liable for all partnership obligations. However, there is no personal liability for debts incurred by the partnership prior to that person becoming a partner. A judgment against the partnership is not by itself a judgment against a partner. A judgment against a partnership may not be satisfied from a partner's assets unless there is also a judgment against that partner. So if you're suing a partnership, you're going to name the partnership and all of the individual partners. But people get a little sloppy sometimes. Purported partners. A purported partner is liable where he represents or allows himself to be represented as a partner to any third party who relies on that representation. Partner rights and duties. Each partner has a partnership account. So again, each partner has a partnership account, which consists of money and property contributed and distributions made by the partnership, less liabilities distributed and shares of partnership losses. Each partner has equal rights in management. So again, each partner has equal rights in management. Each partner can only use partnership property to benefit the partnership. Each partner is entitled to reasonable compensation for services in winding up. So it's reasonable compensation for services in winding up, but not compensation for services performed for the partnership. Decisions within the usual course of business are by a majority. Decisions outside the regular course must be unanimous. Okay. A person may only become a partner upon the consent of all the partners. And a partner is not entitled to receive distributions in kind. Each partner has a right to access books and records, including the right to inspect and copy. So standards of conduct of partners. First is loyalty. A partner must account for any personal profits. So again, a partner must account for any personal profits received in connection with partnership business. A partner may not deal with the partnership in an adverse way. And a partner must refrain from competition with the partnership. The next standard of conduct is care. Under the standard of care, a partner can't act in a grossly negligent or reckless way or with intentional misconduct. A partner owes a duty of good faith and fair dealing. Okay, so actions by partnerships and partners. A partnership can bring an action against a partner for breach of the partnership agreement or for violation of a duty owed where the violation caused harm to the partnership. And a partner himself can bring an action to enforce his rights under the partnership agreement or to enforce other rights under this act. A partner can only transfer his economic interests. So again, a partner can only transfer his economic interest in the partnership. This means generally his share of profits and losses, his right to receive distributions, but not his interest in management. Okay, dissociation. A partner can dissociate by giving notice. So a partner can dissociate by giving notice of his express will to immediately withdraw. A partner can dissociate upon the occurrence of an event specified in the partnership agreement. And a partner can dissociate by being expelled. So a partner can dissociate by being expelled by a unanimous vote of the other partners if it is unlawful to carry on with that partner or if the partner has transferred all of his transferable interests. So wrongful dissociation. A dissociation is wrongful if it is in breach of the partnership agreement. So it's in breach of the partnership agreement. If before the expiration of term a partner withdraws, a partner is expelled by judicial order, or a partner is a debtor in bankruptcy. The effects of the partner's dissociation. First, the partner's right to participate in management and conduct terminates. So his right to participate in management and conduct terminates. His duty of loyalty terminates. But a partner's duties of care and loyalty continue for transactions occurring before the dissociation. A dissociated partner can remain liable on transactions occurring up to 1 year after the partner dissociates. So again, that's remain liable on transactions occurring up to 1 year. If first, the other party believes he was still a partner and did not have notice, but the dissociated partner can file a notice of dissociation, and then he'll remain potentially liable for 90 days. So dissolution. A partnership at will dissolves when a partner withdraws. A partnership for a definite term dissolves within 90 days of a partner's dissociation by death or wrongful dissociation. Dissolves where it is the express will of all partners to wind up. So again, it's the express will of all partners. Dissolves at the expiration of the term. Dissolves at the happening of an event specified in the partnership agreement. And dissolves on application of a party, and it is judicially determined that first, the economic purpose is likely to be unreasonably frustrated. That's the economic purpose. Or it is not lawful to carry on with a partner. Or it is not reasonably practical to carry on pursuant to the partnership agreement. So partnership continues until it is finished winding up. However, the partnership can waive its rights to wind up and terminate the partnership if the partnership resumes business as though the dissolution never happened, and the failure to wind up will not adversely affect a third party. Okay? So now we're on to limited partnerships. Generally, a person can be both a general and a limited partner, with his duties dependent upon which capacity he is acting. A limited partnership has a distinct existence, and a certificate of limited partnership must include first the name of the limited partnership. That's the name of the limited partnership. The name may contain the name of any partner, including a limited partner. You know, off topic, but when I went to school here, this room was always hot and humid. And I can't believe that's not fixed yet. So, anyway. Yeah, it's just nothing. The name must include some indication of the limited status. The certificate must also include the name and business address of each general partner. Whether the partnership is an LLLP, and where there has been substantial compliance with these requirements, the document is effective when filed. So now the records office. The limited partnership must designate and maintain a designated office and a registered agent and registered office. The records office must maintain a current list showing the full name and street address of each partner and separately identify the general and limited partners. Let's have copies of filed documents, copies of the last 3 tax returns, and a copy of any partnership agreement and all amendments thereto. The partnership agreement, this governs the relations among the partners and between the partnership and partners. The partnership agreement cannot, first, vary the power to sue and defend in its own name. Second, vary the applicable law. Third, vary the maintenance and signing requirements. Fourth, restrict the right to information. Fifth, eliminate the duty of loyalty of the general partner. But it can identify specific types of activities that do not violate the duty of loyalty. And it can't unreasonably restrict the duty of loyalty of the general partner. Limited partnerships, unlike general partnerships, can carry on not-for-profit activities. When you're thinking about that, consider the definition of a regular partnership, right? 2 or more persons to carry on a business as co-owners for profit. So that for-profit is part of the definition, okay? Partner contributions. The form of contribution. So again, that's the form of contribution can be any pecuniary benefit, including money, services performed, promissory notes, other agreements to contribute cash or property, and contracts for services to be performed. The obligation to contribute shall be in a record signed by the partner. Okay, again, the obligation to contribute shall be in a record signed by the partner. Performance is not excused by death. So again, performance is not excused by death, disability, or inability to perform. Profits and losses are allocated on the basis of the value of the contributions. All general partners are jointly and severally liable. So all general partners are jointly and severally liable but not for obligations arising before they became a general partner. The limited partnership itself may be liable for loss or injury occurring as a result of a wrongful act or omission or other actionable conduct of a general partner acting in the ordinary course of activities. The limited partner's liability, the obligations of the limited partnership are not the obligations of a limited partner, whether in contract or tort, even if the limited partner participates in management. Rights of partners. A limited partner has no power to act for or bind the limited partnership. And a limited partner can inspect and copy documents after 10 days' notice. No particular purpose is necessary with respect to required information. With respect to information on the state of activities of the financial affairs of the limited partnership, the person requesting must have a purpose directly connected. So they must have a purpose directly connected to the limited partner's interest as a limited partner. The limited partner must make a request describing the records sought with reasonable particularity. And the information sought must be related to the purpose described. Okay. Management rights of general partners. Each general partner has equal rights in management. And decisions are generally made by a majority of general partners. Some decisions require the consent of all of the general partners.
Decisions are generally made by
A majority. Yeah. That's a simple majority in this case. Some decisions require the consent of all of the general partners. Amongst these are first, amendments to the partnership agreement. Second, amendment to the certificate of limited partnership. Third, admitting a new general partner. Fourth, admitting a new limited partner. Sixth is expelling a limited partner. Seventh, dissolving the limited partnership. And eighth, approving a merger or conversion. Each general partner has a right to inspect required information and other information relating to the activities and financial condition of the partnership. Distributions. A limited partnership may not make a distribution in violation of the partnership agreement. It's in violation of the partnership agreement if the equity and solvency test is not met. And if the balance sheet test is not met. So for limited partnerships, you're considering the same tests as a corporation, and you're adding the violation of partnership agreement.
It's either or
Both.
the other.
Sort of the lesser of. So really, you have to meet both. Okay? Or you can distribute to the extent, whichever one results in a smaller distribution, that's the maximum amount you can distribute. So you have to run both the equity and solvency and balance sheet tests. Okay? But again, with partnerships, consider also whether the distribution is in violation of the partnership agreement. Okay, a general partner who consents to a wrongful distribution is personally liable to the LP to the extent the distribution was wrongful. So just like the board of directors in the corporation. Okay, dissolution and dissociation. You must file a certificate of dissolution. The certificate must include the name, date of initial filing, and the reason for the current filing. A limited partnership is dissolved upon first, an event specified in the partnership agreement. Second, the consent of all general and limited partners. Winding up. After dissolution, the LP continues only to wind up, which includes discharging its debts, filing a statement of termination. So now, derivative actions in the LP context. A partner need not first make a demand on the limited partnership if he can prove the futility of making a demand. So this is completely opposite to corporate law, right? Under corporations, we had the universal demand requirement. So here you can prove demand futility. An annual report must be filed. And if, there should be one, if one believes in good faith that he is a limited partner, he is not liable for any obligations of the limited partnership simply by making an investment, by receiving distributions, or by exercising the rights of a limited partner. But he may be liable to a third party who believes he is a partner, and this belief is in good faith. Now, I guess you're the lucky group that are taking the bar right after we have a new LLC Act. So good for you guys. I don't know how long ago you've taken business entities, but yeah, we've got a brand new LLC Act that became effective January 1, 2014. So, shooting just. I'm sorry.
Erroneous belief?
Mm-hmm.
What you have written after that?
Yep. If one believes in good faith that he has a limited partner. It should be, yeah. Yeah, sorry. That's what I get for dictating. Limited liability companies. So again, we've got a new LLC Act. It became effective January 1, 2014. So it really is pretty new. There's not a lot of case law for it, so we're going pretty strictly statutorily. Okay. LLCs could previously have a managing member. This concept has been deleted. So the term has been clarified so that it no longer makes the LLC manager managed. The general default rule is that the LLC is member managed, and all members have apparent authority to bind the LLC. So in other words, there's a lot of work out there right now when you've got an LLC that was formerly had a managing member appointed, because under this statute, that LLC became member managed, meaning all members have the ability to act or bind the LLC, which is not the intent of the people if they had a member managed or a managing member for their LLC. So for what it's worth, there's a lot of work there right now. So the definition of member has been changed to permit a member to have voting or management rights without being entitled to any distributions. And the term transfer is now more broadly defined. And it applies to any assignment, sale, gift, encumbrance, transfer by operation of law, or other transfer of a member's interest. A transferable interest is limited to the right to receive distributions. Okay, so there's some kind of housekeeping coming from the definitions section of the new statute. LLCs are governed by operating agreements, to which the law of contracts generally applies. The operating agreement can be written or oral, Note the term operating agreement presupposes the existence of the entity, so pre-formation agreements are not operating agreements. Okay? So in practice, you got to file your articles before you have them sign the operating agreement. Okay, I think for most firms, we used to be a lot sloppier about that. You'd have them fill out the articles, and you'd go ahead and do the operating agreement and have them sign it. You can't do that anymore. So the operating agreement, the LLC itself can enforce the operating agreement, and the statutory provisions regarding operating agreements. First, operating agreements are primary in evidencing the relationship of the members to each other and to the LLC, the rights and duties of managers, and the activities and affairs of the company. The LLC statutes are default rules, so a lot like partnerships. There are non-waivable statutory provisions. We'll go through some of those in a minute. And there are certain provisions authorized unconditionally, and some limited to being, quote, not manifestly unreasonable. So again, it's not manifestly unreasonable, which is defined and considered further below. Confirms the operating agreement may set forth specific penalties or consequences for failure to comply. So in other words, your operating agreement can now contain provisions setting forth the penalties if somebody breaches it. It's a little strange. Not quite sure how that's going to work in practice, but the statutes authorize it. Non-waivable provisions in operating agreements, the first of which is judicial dissolution. Second is to unreasonably restrict the right of a member from bringing direct action against the company, another member or manager, or maintaining a derivative action. Third is unreasonably restrict the inspection and copying of records.
What was the last one?
Unreasonably restrict the inspection and copying of records. The operating agreement may not exonerate a person from liability for conduct which involves bad faith. So for conduct which involves bad faith, willful or intentional misconduct, or a knowing violation of the law. The not manifestly unreasonable standard is applied with respect to the elimination, alteration of the duties of loyalty, care, good faith, and fair dealing. A court must decide. So a court must decide as a matter of law, so this will not be submitted to the jury, Okay, the court's deciding it as a matter of law, whether a term is manifestly unreasonable. The court may invalidate only if it is readily apparent that first, the objective of the term is unreasonable, and the term is an unreasonable means to achieve the provision's objective. So I think, I'm not really sure how they're going to test not manifestly unreasonable, but I would think they would have to make it pretty egregious. I was trying to look for some cases on this, and it's too new. There just isn't much out there. So just, I guess, keep in mind not manifestly unreasonable and what that might mean to you, or to a court, more importantly, I guess. The operating agreement is generally not subject to any statute of frauds other than obligations relating to capital contributions. So this is a little goofy because remember, generally operating agreements are construed under the law of contracts. So formation, an LLC must have at least one member for its formation. The name, address, and identity of the registered agent must be included. And the operating agreement should indicate whether the LLC is managed or managed. A person may bind the LLC in any of the following ways. First, as an agent of the LLC. Second, by grant of authority in the articles. Third, by grant of authority pursuant to a filed statement. Fourth, having the status as an agent, authority, or power. Or fifth, in member-managed LLCs, the members have statutory apparent authority. So again, they have statutory apparent authority. Now there's a new concept under the new statutes, statements of authority. The new act allows LLCs to file statements of authority.
So they can have manager, it can be managed by manager.
You can have a manager managed, yeah. But if you formerly had a member appointed as the managing member, that's no good anymore, yeah. Okay? A member can be, but your LLC has to be considered manager managed. So you could have a person who's a member who's also acting as the manager, but they're no longer, you can't consider them any longer to be a managing member.
Oh,
Okay, they have to be considered as a manager. Okay?
For formation of LLC, doesn't it have to be filed?
Yes. You file your articles of organization. Okay.
Is it a certain place where it has to be filed?
Secretary of State, Division of Corporations. Yeah. And I mean, if you're interested, you could hop online, and it sort of walks you through what it's going to look like. The new form's goofy. It's bizarre. Okay. So statements of authority. The new act allows LLCs to file statements of authority with the state, which gives record notice to third parties of a person's power to bind or limitations of same, the LLC. So I would think that this could be, the questions that could arise with this is you could have an LLC with like 30 members, and the LLC files a statement of authority that says these 10 people can bind the LLC, these 20 people cannot. Okay, as long as you've properly filed that, third parties have notice, and they need to do an investigation and see if the party with whom they're dealing has the authority to bind. Okay? Now, with respect to real property, the statement of authority must be recorded in the local jurisdiction. So that would just be recorded with the clerk of court for whatever county you're in. Unless canceled, a statement of authority is canceled 5 years after the date of the statement of authority. So I guess unless earlier canceled, a statement of authority is canceled 5 years after the date of the statement of authority. So members, how to become a member. First, the operating agreement can provide requirements. So the operating agreement can provide requirements. Or your admission as a member occurs as a result of a merger, interest exchange, conversion, or domestication of a foreign LLC. Third, with the consent of all other members. Formerly, the statutes required a majority in interest. Now it's unanimous. Okay. Where an LLC is being dissolved and the LLC has not had a member for at least 90 days. So where an LLC is being dissolved and the LLC has not had a member for at least 90 days, a member may be admitted by consent of the majority in interests of the transferees. I'm not sure how this would happen, but both the statutes and the legislative authority kind of spend a lot of time going over this point, so just memorize it for what it is. Contributions to the LLC can be cash, promissory notes, services performed, contracts for future services. Liability for a contribution must be in writing. So liability for a contribution must be in writing and signed to be enforceable. Once enforceable, performance is not excused by death, disability, or inability to perform, just like our LPs. Distributions are made on the basis of the agreed value of contributions. Just like with corporations, distributions are limited by balance sheet and equity and solvency tests. Now, liability for improper distributions. So again, it's liability for improper distributions, like corporations, but a member of a member-managed LLC will not be personally liable if the operating agreement expressly relieves him of the authority and responsibility to consent to distributions. Persons who knowingly received an improper distribution may be liable for contribution. Any action to recoup improper distributions must be commenced within 2 years. Okay, so now the nature of the transferable interests in the or membership interest, excuse me. Transferable interest, we kind of hit this at the very beginning. Transferable interest means the transferee's right to distributions, whereas interest under the previous act referred to distribution rights, voting rights, management rights, and any other member rights. A transfer of a transferable interest does not cause the transferor's dissociation. The transferee is entitled only to receive distributions the transferor would have received. The transferee is not entitled to participate in management or access records. Okay, so again, the transferee is not entitled to participate in management or access records. Voting in LLCs. First, we'll consider member managed. Each member has the right to vote, proportionate to his then current percentage interest in profits. The vote or consent of a majority in interest versus per capita simple majority is required. Okay, so under the old statutes, per capita simple majority was all that was needed. So now it's the vote or consent of a majority in interest. Unanimity is required first to amend the articles. So again, that's to amend the articles, to admit a new member, to expel an existing member, or for dissolution. If a member has transferred his interest to a person who is not a member, the transferring member is still entitled to vote. So he's still entitled to vote. Proxies may be appointed. Okay, now with respect to manager managed, each manager has equal rights in management, and an affirmative majority vote is required. So again, an affirmative majority vote is required. Unless the action is taken without a meeting, then a unanimous consent is required. An act outside the ordinary course requires unanimity. Okay. Dissociation. In addition to dissociating due to bankruptcy, dissolution, and winding up, or the occurrence of an event stated in the articles or operating agreement, excuse me, a member can also dissociate by voluntary express will and involuntarily by expulsion. A member can dissociate wrongfully or rightfully at any time. A wrongful dissociation can incur liability to the LLC and remaining members. Expulsion. So again, expulsion can occur as prescribed in the operating agreement or if the members unanimously agree to expel. Okay. Expulsion by unanimous agreement is only available where the LLC cannot lawfully carry on with that member. If it cannot lawfully carry on with that member, the member has transferred his entire transferable interest, or the member to be expelled is an entity which has been dissolved. So creditor remedies. First, in a multi-member LLC, a judgment creditor can obtain a charging order. So a judgment creditor can obtain a charging order against the judgment debtor's interest so that the company would pay the judgment debtor's distributions to the judgment creditor to satisfy the judgment. In a single-member LLC, where the judgment would not be satisfied within a reasonable time, the court may order the transferable interest to be sold at foreclosure. So, sold at foreclosure. The purchaser, acquires the entire LLC interest, not just the transferable interest, and becomes the sole member, and the judgment debtor is deemed dissociated. So be careful here whether you're looking at a multi-member or single-member LLC. Okay, so management of LLCs. Member managed is the default designation. In a member managed LLC, all members have management authority. Okay. A member is not entitled to compensation. So a member is not entitled to compensation except for services performed in connection with winding up. So like a partnership. In a manager-managed LLC, managers are chosen with the consent of members holding greater than 50% of the then current interest in profits. Okay. A manager will continue to act as manager until first, a successor is chosen. Second, the manager resigns, is removed, or dies. Third, if the manager is an entity and the entity terminates. Okay. Duties and standards. First, loyalty. Loyalty includes accounting to the LLC and holding as trustee and first winding up. Second, in the use of company property. Third, appropriation of company opportunity. Next under loyalty is refraining from dealing with the company in an adverse way. It's refraining from dealing with the company in an adverse way and refraining from competition. Okay, the next duty or standard is care. Under the standard of care, one cannot engage in grossly negligent or reckless conduct, willful misconduct, or a knowing violation of the law. So conflicts of interest. A manager or member does not violate a duty solely because his conduct furthers his own interests. A transaction between the LLC and its members or managers, or another entity in which its members or managers have an interest, is not void or voidable. So, is not void or voidable because of that relationship or interest, or because the members or managers are present at the meeting at which the transaction was authorized or approved, or because their votes were counted for that purpose. If the transaction is fair to the LLC, neither equitable relief, damages, or sanctions are available. Fair, under the statutes now, means that the transaction considered in its entirety is beneficial to the LLC and its members. Okay. Records in an LLC. If member managed, each member has unlimited access. So each member has unlimited access to information concerning the company's activities and affairs, financial condition, and other circumstances that the company knows and is material to the proper exercise. To the proper exercise of the member's rights and duties under the operating agreement. This next one's a new one. Unless the company reasonably believes the member already knows the information. So if somebody's requesting something and the company reasonably believes that person already knows it, there's no duty to produce. I'm not sure how you'd establish what the company believes. It's bizarre. But anyway, the company shall furnish on demand other information concerning the company's activities and affairs, financial condition, and other circumstances, except to the extent the demand is unreasonable or otherwise improper. This is another new one. The duty to furnish requested information extends to any member to the extent the member knows any of the info. So again, I don't know how you'd enforce that. But now every member has a duty to furnish anything they know upon request, unless they believe the other member knows the information too. Okay, if manager managed, each manager has the same right of access that inure to members. A member can inspect and copy the current list of names and addresses of members and managers, a copy of the then in effect operating agreement, a copy of the articles, the 3 most recent tax returns, and 3 most recent year's financial statements. A member may seek other information if first the information is sought for a purpose reasonably related to the member's interest as a member. The member makes a demand describing with reasonable particularity. So again, the member makes a demand describing with reasonable particularity the information sought and the purpose of seeking the information, and the information sought is directly connected to the member's purpose. The company has 10 days to respond. And sure, that's what I think is the important stuff under the new statute. So, thanks. So, good luck. Yeah.